Appearing in the appeal, Cenac and others against Schafer.
Yes. Mr. Snack.
Milad.
First of all, can I be sure I pronounced your name correctly? Snack, is it?
Yes, it is.
Thank you very much. Yes. Yes, please start.
Milad, I appear on behalf of the appellants in this matter, Serioja Snack, and appearing with me is my learned friend, Mr. Leslie Prosper.
Yes.
Milad, before I begin, I wish to apologize to your lordships for the timeliness of the submission of the bundles, as well as the e-bundle version, which I understand arrived only yesterday.
Yes, well, never mind, we are where we are. It is quite confusing to find the particular documents by reference to the references that we've got in the bundle, but I dare say we'll manage.
Thank you, Milad. Milad, I wish to open my remarks by first making plain a few critical points to rightly conceive the appellant's case. Firstly, we think that the appeal treats with the novel question that no earlier case has yet decided of how a purchaser for value affects the defeasible interest of an unlicensed alien. Secondly, while the appellants accept that there was an agreement between the Smiths and Mr. Hedrick, in this case, however, too much emphasis was given to the proof of the contract rather than to the sufficiency or manner of its performance, as the contract was not performed in accordance with law. My lords, what is the...
So the existence of the contract is not in dispute?
No.
Yeah.
My lords, what is deducible from the authorities is that notwithstanding a validly formed contract, there may be reasons of fact or law which render that contract void or unenforceable, both in law and in equity. Our contention, therefore, is that the courts below failed materially to consider the enforceability of the contract in light of the objective facts set before them. Thirdly, my lords, inasmuch as the Alien Licensing Act, as it is presently understood, is not relevant by itself for the enforceability of a contract as between the original vendor and purchaser, it becomes highly relevant in assessing the reasons why the contract was performed in the manner that it was, and it impacts on the enforceability as against third parties. In other words, we are saying that but for the Alien Licensing Act, the respondent would not have carried out the contract in the manner that he did. That said, my lords, I wish to distinguish a transaction of an ordinary purchaser and set it in opposition to an alien land purchase transaction. The distinguishing feature, my lords, is that Parliament has legislated an additional requirement for an alien to apply and register a license in order to hold land and to complete the purchase contract. In point of fact, my lords, the alien is a different creature to the ordinary purchaser, and indeed of a different class, that a court of law must give fair regard in treating with the proprietary interests relating to an alien. My lords, I think it is therefore convenient at this point to deal with the decision of Midland, Bank and Green, which is at tab 128. That is in volume 5, my lords, the large bundle. if your lordships actually have the pen drives, that would be at MS 1374.
Is it down there?
Tell him to
Excuse me, it's been down there.
Yes.
28, is there?
128.
128. Yes, well, what do we get from Midland Bank and Green?
My lords, I would submit that it fortifies and adds value to our submission, that in the context, I believe the court may better understand what our submissions are. This is a decision that my learned friends are relying on, but I think it assists our position. In that case, my lords, a son sought to enforce his option to purchase the estate against his father, who had conveyed the property to the mother, at a nominal sum in order to defeat the option of that son. That option was capable of being registered as a land charge against the property pursuant to the Land Charges Act 1925. And I can refer your lordships to page 526, sorry. This is page 1329, 1328, my lords. Part D, paragraph D.
Yeah.
And also 1329, part B. And 528B as well. And 529A. Are you following me, my lord? Yes?
And what do we get out of that in a sentence?
In essence, my lords, that the fact that the son had not registered his option pursuant to the Land Charges Act, his interest was not protected, and the transfer to the mother was deemed valid. So we are saying, by analogy, if we reason, that the Alien Licensing Act, which gives the alien the right to register his interest under the Land Registration Act, once he has procured that license, is similar to the position of the Land Charges Act. And if you have not so registered your license, then he is in the same position as the son was, because he had no valid license and it was not protected under the laws of St. Lucia because he was an alien.
So is your proposition that Mr. Hedrick was not entitled to register his caution?
Yes, and we will come to that shortly, madam.
Right.
Yes.
So, my lords, we are saying that if we apply the reasoning of the learned justices in Green, since the words of the Act are clear, they should be afforded the firm respect as the learned justices in Midland, Bank, and Green did to the Land Charges Act. Because the Alien Licensing Act is clear, we are saying, and it should be given that firm respect that the justices in Green had given to the Land Charges Act in finding that if you had not protected it under the Land Charges Act, it was not so protected under the Land Registration Act.
Yes, the Land Charges Act, the provision that was in issue is at the start of the head note, I take it, section 13.2.
Yes, correct.
Where it says that a land charge shall be void against a purchaser unless it's registered.
Yes, yes. But if I can restate the
Is there
submission
a similar provision in our statute? There's not.
in the Alien Licensing Act, Section 5 would say an alien has no right to hold land unless he obtains a license.
Well, do we not have to read that in the way that the Judicial Committee read it in Young and Bess?
Yes.
Yes, but we will address your lordships on that point later in our
And
submission.
your point is Young and Best has been overtaken by statute. Is that right?
We're saying that it has been repealed by legislative implication.
In the 2002 Act.
Yes.
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 I think it's said that the 2002 Act is, is not retrospective.
Correct. Yes. But I think I will come to that point, my lords, and I hope I will address your lordships on it in due course. And my lords, if I can restate the submission of the learned Queen's Counsel, Mr. Hoffman, and say that what is presented to this court for consideration is that in the case of an alien in St. Lucia, his proprietary interest was merely a defeasible personal right against a third party until a license was registered. So I've restated what the learned counsel Hoffman stated in green, and that was at 517E. Which is page 1319.
Does Mr. Schafer have a license now?
Now.
Yes.
Yes.
Yeah.
My lords, I now turn to the issue of the validity of the caution, which is at page, it's at tab 99 of volume 4. My submissions? Oh, yes. My submissions. It will be at page 852, tab 99.
Sorry, which page in volume 4?
852 on the tab 99.
That's your submission.
Submissions, yes.
Yes.
And I'm commencing at my paragraph 4. Do you have that, my lords?
Yes, we got that.
Thank you. My lords, in treating with the respondent's caution, the courts below had to consider, which they failed to do in our submission, is whether the caution was validly entered. And in support of that decision, we relied on the authority of Cecil Hill, which is at tab 112, which is page 1046. And that decision is authority for the principle that the caution was not in order and was defective. My lords, if we turn to paragraph 31 of that decision, which is at page 1057 of the bundle, so we are referring your lordships to paragraph 31 and paragraph 47 of that decision. And critically, paragraphs 51 to 53 of that decision. So we have it at paragraph 31, paragraph 47, and paragraphs 51 to 53. And in that case, my lords, what the learned justice had to determine was whether the party in that case, which was a bank, AIB, who required a license under the Banking Act or the Financial Institution Act, whether the fact that they had registered a caution in the absence of a license, whether their interest was protected. And based on the paragraph 47, 51 to 53, the court decided that in the absence of the license, the bank was not a recognized person under the law of, I think it was St. Kitts, if I'm not mistaken. and their caution was determined invalid, it was fatal to the AIB's case.
This is on the footing what? That the caution was unlawfully lodged.
Unlawfully lodged.
That's on the basis, is it, that the Aliens Licensing Act did not make any express provision for it?
Correct.
But why, I mean, if there's a general right to lodge a caution in respect of an interest, and if they had an interest, I know you say they didn't, but if they had an interest, why does one need an express right to register it rather than the general provisions relating to cautions?
Well, it's our position, my lords, that a caution gives you a right to register against the property, your interest, or your right. However, the Alien Licensing Act specifically says that if you have no license, you cannot encumber any property in St. Lucia, cannot hold land.
Yes, I understand that, but
Yes.
This submission surely depends upon your contention that they had no interest to register.
Yes.
It doesn't depend upon your contention that there was no provision for registration of a caution in the case of aliens.
In essence, yes.
I see. Okay.
Yes. Because we are joined by the analogy that the bank in Cecil Hill, in order to register the caution, had to have that license, which would have empowered them to place the caution. And in this case, in our case, we are saying that the alien, in order to enter the caution, had to have his license. Because the reason why we started with Midland Bank and Green was to say that the alien is of a different class to the ordinary purchaser. So Parliament has legislated that an alien needs to do an additional thing in order for him to start accruing rights or asserting his rights against parties or land in St. Lucia. And if he has not done this, then he is not in a position to assert that right, particularly against third parties. While he may have a contract, and he can enforce a contract against the party he has entered that contract in asserting that right against a third party, he must have a registered license. Because if he has not done so, his right becomes defeasible. That is our position and our submission, my lord.
At what stage in the transaction of purchase do you say that the alien must obtain the license?
And in the reading of the Alien Licensing Act, it says that on placing a deposit, the alien can at that point, that is Section 7 of the Alien License Act 2002,
Perhaps we could just look at that, could we?
yes, and that would be at tab 102.
Tab what?
Oh, sorry, 102.
102.
Yes,
Sorry.
and that's page 954, Section 7.
Was there an equivalent provision in the 1973 Act, which was governing at the time of the lodging of the caution?
No, my lords, we are saying that it never referenced the issue as to at the point in time which was on the payment of the deposit, he can enter a caution. So we're saying that was the change the Alien Licensing Act made to the 1973 Act.
Yes, but if you're trying to look at the validity of the caution that was
Right.
placed on the register before the 2002 Act, how can you pray and aid the 2002 Act?
Right. So we are saying, my lords, that at the time that he would have entered into a contract, before the conclusion of the contract, because if you look at the form that an alien prepares, it speaks to the land to be purchased. So it is not at the completion of the contract would you apply for a license. So at the point in time where you agree to
Are
buy,
you saying that that an alien cannot validly contract without
can.
a license?
he can contract. He can contract.
Right. And what effect does the contract have?
I would submit, my lords, it would he can enforce his rights as against the vendor on whom he has agreed to purchase, but in order for him to assert rights against third parties and to register his interest against the property, he needs to have this license. As in the decision was suggested in the AIB Cecil Hill decision.
And that was true before this enactment, was it?
Yes, my lord, we would say it was the same, because the transaction, the operation
we need
of...
to look at the previous act, do we, to see
So we can
what
do
the
that.
position was then.
Yes.
It's 101, isn't it?
Yes.
Well, yeah. So which is the relevant provision
We would be relying on section 3, my lords. And my lords, section 4. Do you have that, my lords? Yeah.
Yes, we have that.
My lords, what we are saying is that Parliament has directed that in order for the alien to hold land, he is not meant to complete his contract of purchase until he has obtained a license.
But that doesn't prevent one from contracting or from registering.
No, we are not contending that at all. They can contract.
Yes, but I mean the subject matter of the caution was the contract.
Pardon?
It was,
The subject matter of the caution was the contract, was it not?
yes, a contract purporting to create proprietary interests, or a proprietary interest. So in interpreting that, what we are saying, the court must read the Alien Licensing Act in conformity with the Land Registration Act. So that if your purported contract, which is creating a proprietary interest, in order for you to protect that proprietary interest on the land register, you need to obtain a license for it to be protected. Because if you do not, then you have a personal proprietary claim against. Most likely it would be on a contractual basis. That would be your
What
remedy.
is a personal proprietary claim?
Based on the contract.
I think your distinction is between a proprietary claim that you can register a caution for and a purely personal one which you can't.
Yes. You have it, minutes. Thank you.
Yes, and yes, you're making the civil law distinction between a personal claim which is enforceable only against the contracting party and a proprietary claim which is enforceable against the world.
Correct.
Yes.
Right. So essentially we are saying for the alien to enforce it against a third party, against the world, he must register that license. And that gives effect to the intention of Parliament and upholds the scheme of the Alien Licensing Act. Because we are saying it is a mandatory act. It is not optional. Well, as I think, where am I right now? Mm-hmm.
Caution as noted.
Yes, my lord.
I should go through the estate contract.
Right. My lord, accordingly, I would say what is deducible...
I mean, are there any provisions of the 1973 Act itself which are relevant apart from this substituted section?
Say again? I think it...
Well, we have in the previous tab 101, the 1973 Act.
Yes.
And this is an amendment to the 1973 Act, the one we've just looked at, tab
2002 was...
No,
It repealed the 1973 Act, and
in
it...
its entirety, right.
Yes, in its entirety, and we remodeled the Act and made it a little clearer, if I can put it that way.
But I'm just asking whether there's any relevant provision of the original 1973 Act.
Other than Section 3.
Other than section.
I would say
Well, you said 3 and 4.
3, 4, and 5, my lords, would be the governing areas of the legislation.
Well, it's
And
really
I would
5.
also suggest Section 8 of 1973 Act. So, my lord, what I would say is...
Does section 13(4)(b) of the C rather, of the 1973 Act not recognise the right of an alien to enter into a contract and to have the trust interest which is created by such a contract?
My lord,
without a licence?
my answer is yes, but that trust, the original vendor would only be at liberty to hold it on trust for the alien during the period in which he applies for a license. He cannot do so indefinitely because the Act has actually said that you cannot hold on trust for an alien. And we are saying to construe the Act can only mean within the time you're applying for a license that you are holding this property on trust. Because the Act is expressed and clear, no trust.
Well, that's section 14 of the 1973 Act.
Yes.
That if you want to hold in trust, you need a license, and the
As well.
2002 Act makes it clear, as from then, that's I think section 9, that a trust in section 9 from 2002 onwards includes implied trusts as well
Correct.
as express trusts. Yes.
Because we say when you construe the entire wording of the Act, Parliament is saying that whatever avenue an alien is trying to circumvent, if I can put it that way, obtaining a license, it is precluded. You cannot hold on trust. You cannot create a company to hold it. The alien must apply for it, and that period in which they must apply for it is a 3-month period where the vendor can hold it on trust. And my lord, the final point I wish to make on this is that in the absence of a license, the proprietor did not protect his interests because he had not pursued the correct and statutory method to protect his purported estate contract. And I lifted this from Green again, and I've restated what the learned counsel in that case had submitted to the court. My lords, I wish to move on to the effect of the caution, if the court is not with me in relation to my first submission, and that is at paragraph 4.6 to 4.10, which is page 853 of my submissions. My lords, I wish to rely in essence on the content of my submissions in this regard, because I think it captures pretty succinctly the position of the parties. But what I would only like to add or highlight to the court is that a caution is not intended to be a form of permanent protection, but is a temporary device used to give a party notice of a potential dealing. And we are submitting that if you place a caution in 1991 and you have done nothing up until 2006 to alter the status of that caution, it is a misuse of that temporary facility which the law has afforded you. And when you construe the Land Registration Act in conformity with the Alien Licensing Act, what is the position is if we enter the caution, if the court deems that there was a validly placed caution, that caution could only have been in place for the 3-month period in which he had to apply for a license. And to keep it on the register for a period of 14 years is an abuse of that temporary facility of a caution.
Lillian Riley, yeah?
Did
Lillian
I?
Riley.
I think it's here at the spot. Yeah, no, I'm here. Well, as I now turn to the issue of the caution as notice, which is at page 856.
You say the caution has no effect after 3 months, do you?
With respect to an alien. Because again, I want the court to understand my submission that an alien is a separate creature under the laws of St. Lucia, or a separate purchaser as an ordinary purchaser who is a local or an individual who does not require a license. In other words, a non-alien. That you can purchase land and the ordinary principles of the land registration system would apply to you. But if you're an alien, there's an extra element, and it is governed.
Where do I get the 3-month period in the 73 Act?
I believe that would
The
be.
73 Act would not have cautions, remember? Doesn't the-
No, it says the period in which it is.
That's 30 years, section 13.
And Lord, it should be in the
Section 13.
13.4. Yes, my lord, it's 13.4C.
Subsection
Within 3 months, such payment, the yesterday property is vested in the purchaser. Yes.
I think that's the third point, so you might be right. Lord Hodge, are you happy with that, or can I go on?
Please go on, yes.
Oh, yes. Lord, in relation to the caution as notice, which is at paragraph 411 of my submission, I want to treat with that caution as notice, which we submit. That
Sorry, paragraph what of your submission?
411.
From 411 at page 856. My lords, what we are submitting on this point,
Oh, I see.
page 856, caution as notice, 411.11. What we are saying that the courts below where we are saying the courts below went wrong is that they ignored the more germane question incidental to the deeming provision, which was what notice did the caution give, or what interest was it seeking to protect. And we submit that in the context of an unlicensed alien, it could not be of an interest in land. But again, to use the words of Queen's Counsel Hoffman from the...
Do we see the form of the caution which was entered?
Yes.
Yes, my lords.
Which one is the evidence?
It's 2.1 it should be.
It's a prescribed form, isn't it?
Yes.
Yes, I think at page 199 we have the caution that your client entered. I'm not sure where the caution of the Mr. Hedrick is.
Page what?
199 in volume 2.1.
No, there's the John Hedrick portion. Page 154. What tab is that? Oh. 154.
Oh, yes, there's Mr. Hedrick's caution is page 154 in the same volume.
Yes.
So he claims an interest as purchaser.
Yes.
And forbids the registration of dealings
Yes, ma'am.
without consent.
Yes.
Until the caution has been withdrawn by me or removed by order of the court.
Yes. My lords,
If you say it lapses, do you?
yes, that's part of our submission. And my lords,
So it doesn't
I mean, why does it need to lapse if it can be removed by order of the court?
Well, by the operation of the statute, we would say.
Why isn't it? This is the Land Registration Act
Yes,
form.
yes.
So why doesn't it say it lapses?
Again, my lords, what our submission is that in construing the Land Registration Act, the court must construe it along with other legislation. And we are saying when you import the Alien Licensing Act, which governed this transaction, it does bear relevance on the issue. And what we are saying, in addition, that if the caution is deemed to be valid, it does not prohibit a dealing in the land. What it does is prohibits the registration of any dealing which is inconsistent with the caution. So you cannot register it, the registrar will not register it until she gives notice to the cautioner that there is a potential dealing that affects your interest. And when that notice is issued, the cautioner would come forward to justify why his caution should be preferred above that of the proposed dealing. And my lord, our submission is based on paragraph 4.8 of our submissions, which deals with the effect of a caution. And that is what the learning in Richard Clark and the Chief Registrar and Peter Jamari postulated or enunciated, my lords. Okay, coming to that.
5 minutes.
So, my lord, we are submitting that in the context of an unlicensed alien could not be of an interest in land, and we rely on the authority of Lillian Riley, which is at tab 127, page 11312. We are relying on paragraphs, sorry, Matt. That's tab 127, page 1312.
Paragraph?
Paragraphs 35 to 37. If I could just read those two paragraphs. What is the unregisterable interest that Mr. Gerald has in the property? What is the interest in the land that he's asking the court to protect by the entry of the caution? It is clear that he seems to have a pecuniary interest, one which is only monetary in nature. As a creditor, I must agree with Mr. Brandt that he has not done what was required to establish his interest. At paragraph 36, there is no indication that he had taken steps to pursue such a claim which would allow him to establish his interest. And at paragraph 37, I believe the final line there, the interest in the land must be in existence at the time the caution is lodged. It cannot be one to be established at a later date. I find that Mr. Gerald does not have an unregisterable interest in the property, and there is therefore no basis.
Why hasn't he got an interest voidable at the instance of the state?
Well, I think what he was claiming is set out at paragraph 28 of the judgment. He says he claims an interest for monies, for
Yes.
property tax, utilities, personal sustenance and repairs. So the judge said that he was only claiming money.
Yes, and what we are saying that this decision is authority for is that in order for you to assert your interest, you must take all the necessary steps in law to assert it.
But it doesn't say anything of the sort. What it says is if you claim money, as Mr. Gerald was, according to paragraph 28, then you can't protect your money claim by a caution. That's all it says.
My lord, respectfully, I would say that what the decision is stating is that in order to assert your interest, whatever it is, whether it is a monetary interest, because what he was concerned with in that case was, in fact, a monetary claim. But we are saying the principle is that whatever interest you have, you need to take the required steps in order to protect
If
it.
your interest is an avoidable interest at somebody else's option, why isn't that a sufficient interest?
Assuming that the option hasn't been exercised.
Assuming the option hasn't been exercised.
Yes, but I would submit, my lord, that an unlicensed alien is in a precarious situation, that he has an interest based on contract which he has not protected by an entry.
Yes, but
and
his
a
interest
caution.
is voidable, but only at the instance of the state.
Yes, but if he is unlicensed, the state has not even been brought into the picture because the alien would not have subjected himself to regulation. Because if he has to go to the government to indicate that he has an interest to purchase land. If he has never gone, my lords, he has not put himself within the frame or purview of the Act. Shakespeare
This
says,
case doesn't help you on that. I mean, your basic point that you've made before, and I understand, is that because he hasn't done the necessary things to sort of register himself, he's only got a personal interest.
correct,
That's where you put it. And if you're right on that, then I can see the rest follows. But
yes.
the question is, are you right on that? And so I don't think Riley helps us very much on that, because that,
Very well, my lords, I will,
So we have to identify the interest which is voidable.
yeah.
my lords, what I would say on the voidability is that voidability arises when he has a license. But if he has no license, my lord,
Doesn't arise.
That can't be right.
Once he's got a licence, it must stop being voidable, mustn't it?
say again?
Once he's got a licence, it must stop being voidable, mustn't it? If
No,
he's got a
my lords.
licence.
No, my lords. It's what is voidable is the alien's interest when he acquires the license. If he's in breach of the conditions, then his interest is voidable at the interest of the state. But if he has not subjected himself to regulation, how could his interest be voidable?
You're saying this, of course, ties in with your view that Young and Bess has been superseded by the 2002 Act. If Young and Bess hasn't been superseded by the 2002 Act, then the proprietary interest of the alien in the land is, according to Young and Bess, voidable at the instance of the government.
Yes.
But your submission at the moment depends on your assertion that Young and Bess is no longer good law.
I would say yes, my lords.
So if you're wrong about that, then this point doesn't work.
I wouldn't say it wouldn't work, my lords, because, again, the court must identify the two different situations of an alien who has presented himself and has a license and has therefore been regulated, as compared to an alien who has not subjected himself to regulation to the government. And his position cannot be the same, my lords. Cannot.
So
in law.
you're distinguishing between not having a licence on the one hand and breach of condition on the other.
Absolutely.
Is that a distinction that has been made in any of the cases that we've seen?
There are a number of cases because in the other decisions, my lord, where the Alien Licensing Act arose, there are two separate provisions. And I can't remember off the top of my head the particular sections, but one dealt with a completely unlicensed alien and the second dealt with a licensed alien. So they identified two occasions. But in our 2002 Act, it does not contemplate an alien not having a license. It says the alien must come and be regulated. And if the alien does not have a license, never subjected themselves to regulation, I cannot see, as it is said, my lords, by the learned playwright, that which justice sees, that justice seizes. So if the government of St. Lucia is never aware of this alien, how could he have been regulated? And how can the government take any step to forfeit? They can't, because they're not aware that he's here. Now, I would give an analogy, my lord, that any individual can drive a vehicle unlicensed. He has that freedom to do that. But it doesn't negate the fact that the law requires, and it is mandatory if you drive a vehicle, that you need a driver's license. And what occurs to this individual when he is stopped by chance? so to speak. And this is our very position. He did not subject himself to regulation by having a license. So when the purchase happened by the appellants, what was his position? We are saying that he had no interest there to assert against a third party. Because there is a relationship between the government and the alien, and we are saying when you read the Alien License Act and the Land Registration Act, it also affects his interest, his ability to assert his interest as against a third party. Well, that's,
It's 45, we're not 45.
yeah. I also
It's very cool.
wish to rely on...
Young and Best was a case where there was no licence. It wasn't a case of a breach of condition.
Youngin, yes, my lords, yes.
So your proposition that you have no interest if you have no licence, as opposed to the position if you are in breach of licence condition, contradicts Young and Best, doesn't it?
Yes.
Yes, it depends on Young and Best being superseded by the 2002 Act.
Well, if that's a critical point, perhaps we should turn to that.
Well, I don't think, because we wanted to address it last, because however the Young and Best issue was decided, we still believed that in construing the position of the alien was consistent with our position. But whether or not that his interest was voidable at the state, what needs to be determined is the validity of the caution, the effect of that caution as notice. It still has to construe it, whether that purchase was entered into as bona fides, and the weighing of the two equities that were created as a result.
Right, yes?
Well, as if I can turn to the issue of good faith, which are at paragraphs 7.1, 727, which is at page
865 onwards.
865. Thank you, Milad. And we are relying on our submissions from part 7.1 to 7.27 on the issue of good faith. And in particular, we reference 7.3.
This is the good faith of your clients.
Yes, the appellants, the first and second appellants. My lords, on the first issue, I wish to state is that in this case, there was no possession of the property.
By the respondent.
Yes, by the respondent, my lords. And it's a principle of law which is often stated that possession is 9/10 of the law. So if there was no possession of the property, one can say that the appellants would have been 9/10 satisfied that there was no interest in the property. Then he had to go and look at the state of the registry.
Where does good faith fit into the legal structure?
The
Is it part of a submission that your client was a purchaser in good faith
Yes.
without notice?
Yes, yes,
But you need both components. You need both good faith and without notice.
yes,
We know there was a caution
yes,
which gave notice.
yes.
So how does good faith on its own get you over that?
Well, we are
And
saying,
if there's no proprietary interest that binds you at all,
yes,
then good faith without notice doesn't matter.
yes,
If, on the other hand, there is potentially a proprietary interest which requires your clients to have been a purchaser both in good faith and without notice,
yes.
then you had notice. So good faith doesn't help you. So I'm a bit puzzled about why this is an important point.
Well, my lords, what we are saying, which is why we,
There's some sort of notion of balancing the equities.
yes, when we started off with caution, and what was the notice that it gave, right? Because it's not that there was a caution and gave notice. What the court has to look at is what notice did the caution give.
And it claimed, we've looked at it, and it said that Mr. Hedrick was a purchaser.
Yes.
Yes. And that gave you notice that he was claiming the right to purchase the property.
Yes.
And your client never actually approached Mr. Hedrick or his executor to say, well, what is the state of play? Ever.
Yes.
He didn't.
No.
Well, how can he get over the notice that he'd received in the caution?
Well, my lords, what we are submitting is at paragraph 73, and if we can look at the affidavit of the respondent.
Tab 2.2.
Well, the respondent's affidavit it does not mention this property. His probate affidavit doesn't mention the property. That is correct.
Right.
So you made certain inquiries, including, as you say in 7.3, you inquired of the Smiths and you inquired of the probate registry, but you did not inquire of Mr. Schafer.
Correct. So Mr. Schafer is the individual who swore the affidavit and disclosed of only 2 properties in St. Lucia, which was at Colibri Estate. And
Sworn evidence.
yes, so that's
That sounds to me like a sort of never underestimate the value of prejudice point.
well, my lords, what our submission is that when party has sworn evidence, a party can rely on the security of that oath, because this is a document that is sworn and is in a public registry, and a party ought to be in a position to rely on that without having to go further and inquire to the party himself.
So it counteracts the caution. Is that really what you're saying? It nullifies the caution.
Well, what our submission is in total, my lords, when you construe the 2002 Act, which says that an alien has no interest in the land, but if he has placed a deposit, he can put a caution for that deposit. So what that caution would have given notice of, that I have an interest in that deposit that I have paid, because he has not created his proprietary right as yet. He requires a license before that proprietary interest can be converted into a proprietary
Back
interest.
to the 2002 Act.
Yes.
So you rely on you rely on your argument that the 2002 Act has superseded Young and Best to mount this argument that the notice was rendered ineffective by such inquiries as your client made.
So it was not a notice affecting the land. That's what we are saying. Because always remember, our point is this.
But it would have been tested as at 1991, wouldn't it?
Yes, but the position is the same, my lords. That this 1973 Act says an alien has no interest in land. So whatever he registers on the register cannot be construed as protecting an interest in land.
Yes, but that can't have been the position as of 1991, because at that stage, the only legislation in existence was the legislation construed by the Privy Council in Young and Bess.
But at that time, my lords, the 1991 Young and Best came in 1995. So Young and Best would not have ruled that. What was the governing decision was Chase Manhattan and Kafka, which determined.
Yes, but that was overruled
Yes.
by Young and Best.
Yes.
So in that context, the correct law in 1991 was Young and Best. And on that basis, Mr. Hedrick was able to obtain a proprietary interest, an equitable interest in the land once he'd paid the purchase price in full.
Right.
So
So
it was voidable. You say, and you're coming to this later, that this is changed by the 2002 Act.
yes. But I think we are going a little further and saying that Young and Best would determine the interest between the contracting parties, but it has not yet determined what is the state of play in relation to an unlicensed alien, how it affects a third party who has come to look at the state of the registry. It has not determined that issue. No, Mr. Chairman. Yes.
Yes, right. Well, you've got halfway through your time now.
Yes, my lords. Thank you. And my lords, if I could also quote again from the excellent playwright that when Henry V went to the Archbishop of Canterbury and said to him, "May I with right and conscience make this claim?" And the Archbishop said to him, "There is no bar to make against your Highness's claim in France, but this which they produce from Pharamond." And we're saying this claim that they produce from Pharamond is the caution. Notwithstanding this caution, my lords, we are asking whether or not that notice that it gave was notice to the first and second appellants, that it precluded them from entering into the transaction that they did. It was based on the understanding of the law, was that no unlicensed alien had an interest in land. And I wish to refer your lordships to tab 59 of volume 2.2.
This is a letter from your firm.
Yes.
The registrar.
And my lords, we are saying that this letter sets out the reason why the transaction was entered into and the understanding of the appellants as to the operation of the law and the Alien Licensing Act in relation to the Land Registration Act.
But I mean, that's really your submissions to us, isn't it?
Yes, and I'm asking the court to consider that in light of the good faith argument, because the appellants would have been advised based on that understanding that is set
Yes,
out.
I mean, your client proceeded in good faith in the sense, presumably on your advice and your view of matters. So I don't know if there's anyone questioning that.
Yes.
The question is whether that makes any difference.
Very well, my lords. And I also wish to refer your lordships to tab 34.
34.
34
Of the same bundle?
No,
to 1.
2.1.
2.1.
Yes, my lords, at page 186, because what the courts below decided was that the appellants, first and second, ignored the notice of the caution.
Sorry, page 186.
186, paragraph 5, and that discloses that the appellants did not ignore the caution, but included it in the deed document, which is seeking to transfer the legal title. And there it says, whereas the vendors have agreed to sell and the purchasers have agreed to purchase the property which formerly belonged to them for consideration of $560,000, subject to the caution for $201,000, which shall rank as a first charge on the property, and subject also to the privilege of vendors for the remaining balance of $305,000, which said privilege shall rank as a second charge. And if we have a look at page 188, the second schedule, which sets out that the first charge to the heirs of the deceased, the sum of $201,000, which is registered as a caution against the property, and to pay the same upon the removal of the caution, which shall rank as a first charge against the property. So the court below could not have concluded that the appellants had ignored the caution. They took it into consideration based on the March 1st letter in how they construed the notice that the caution gave. There was no license, and therefore it did not protect a proprietary interest, and therefore the deed document could have been executed, and they made the caution subject, the registration of deeds subject to this caution.
Well, how could they make it subject to the caution? Because all the caution did was forbid the disposition?
No, my lords, we're saying it didn't forbid disposition. It
that's-
forbid the registration.
It forbade the registration, but I mean, to give yourself a real right, you wanted registration of your deed of sale.
Yes.
And until the court removed the caution, you would not get that.
Will not get registration. Yes.
Get registration.
Accept that.
So your attempt to get round the caution then was to give a security over the property that your client was purchasing to the extent of what you understood the interest that was being protected by the caution.
Yes.
And the 201,000 figure was obtained how?
That would have been the deposit, the $75,000 deposit.
Well, how did that, $70,000 US dollars
Yeah,
is
converted.
201,000 East
Yeah.
Caribbean dollars?
Yes.
I see, thank you.
And my lords, I did not include Article 956 of the Civil Code in the list of authorities, which was something I came across only subsequently, so the court will forgive me for not being able to refer your lordships to it. But at Article 956 of the Civil Code, it states...
Do you have a copy?
Sorry?
No,
Do you have a copy?
No, but one can be made available because I have it on you.
Article 956.
956, on that, which says the obligation of a contract extends not only to what is expressed in it, but also to all the consequences which, by equity, usage, or law, are incidental to the contract according to its nature. So we are saying, what was the nature of this contract? It was an alien transaction, and it was subject to all the consequences by law which the Alien Licensing Act mandated. So in construing that proprietary interest, it was relevant, my lords, and the court needs to consider the fact that the alien did not have the license and he has not done all that was required by law to protect that interest. My lords, we also rely on the position, paragraph 7.7 and 7.8 of our submissions. And also we rely on the authority, the respondent's authority of Royal, Brunei, and Philip, which is at tab 137.
$127.
137, my lord, sorry.
Or benign tan, yes.
Yes. And my lord, 137, yes. What that case decided was that, well, I don't want to be guilty of being a head note lawyer, but if you look at page 1436, part 36, page 1436, volume 5, yeah, 137,
This is the second part of the head notes, yeah?
yes, where it says held, I think it captures in essence the decision of that case is sufficiently instructive as to the point I wish to make. But in the body of the document of the authority, it covers the simple submission that in assessing good faith, what the court needs to determine is the state of mind of the parties, and relying on Smith and Morrison, it is the honest belief of the party, and you also have to consider the experience of that individual and what it is that he considered in coming to that decision. And we are saying in this case, the first appellant was a former legislator as well as a former minister. He was in a position to know the purport of the Alien Licensing Act. And it is throughout the evidence that as early as 1986, he expressed to the parties, the first party that purchased from him, that land in St. Lucia is not to be speculated on. And speculation means you cannot hold land without development. He expressed the same to Mr. Hedrick. He expressed the same again to the government in 2002 in relation to what he saw as a caution. And he stated to the government that this individual, if he has that interest in the property, is merely speculating. And under the Alien Licensing Act, it is forbidden it is unlawful to speculate on land in St. Lucia. And if the court has found that there has indeed been speculation, that is a factor that they can consider in enforcing any legal right that they believe that the alien had. Because we're saying speculation under the laws of St. Lucia is unlawful. And if you are asserting an equitable...
But if done by an alien?
If done by an alien, yes. And we will come to that point, my lords, because it's highly relevant, because the Parliament has specifically legislated against, and there is a strong public policy purpose for doing that, my lords. And we are saying that the first appellant was in a position to know what is the true purpose of it. And my lords, I have not come to that position, that argument as yet. But I would say, my lords, and I wish to say it now, is that while we respect the powers of the court to construe legislation, the court can only divine what it is that Parliament has intended by construing the Act, which the court endeavored to do in Young and Bess. But in this case, the court had evidence, direct evidence, by an individual who knew, who was in a position to know. He was a former legislator as well as a former minister, and by that right he sat in cabinet.
But what's all this got to do with it? I mean,
yes, that goes to the state
is
of...
the best case wrongly decided, is it or what?
Yes, so what we're saying is that it goes to his state of mind.
But I mean, your state of mind, we've been over this, and as you say, your client acted perfectly in good faith on the basis of the advice he was given and his own knowledge. But that's, as my lord has said, that doesn't really get you home, because
yes.
he had notice. And
right, so
that
what we're
comes
saying...
back to the point of what he had notice of. That in turn gets you back to the question of what is the effect of the legislation in the light of Young and Bess. So we always come back to that key point, which you keep on tantalising us with, but don't get to.
Very
We better press on, because we haven't got all that much longer.
Yes, my lords, I would go to, therefore, the position of Young and Bess, and that is captured.
Where are you now? Page 10?
Yeah, let me just jump. Right, that's at paragraph 16, my lords.
Of your argument?
Yes, 889, page 889. Oh, page 11.
Yes.
My lords, what our position is in relation to Young and Bess is that we accept that the Privy Council in Young and Bess made a ruling as to how the Alien Licensing Act was to be construed. That was in 1995, and it determined that Chase Manhattan and Ramsaran, which Chief Justice Robotham had decided in both these cases, should not be followed and was overruled. But our submission is that that case was determined on the words subject to the provisions of this Act, which was the 1973 Act. And Young and Bess emanated from St. Vincent, and most of the Alien Licensing Acts throughout the region are quite similar. And our provisions of Section 3 of the Alien License Act 73 has the same wording, subject to the provisions of this Act. So whilst Chase Manhattan and Ramsaran had determined that without the license, the alien, or in the breach of the license, the alien had no right to assert, it was automatically forfeited. And the Privy Council in that case determined that in construing the entirety of the Act, you had to take in consideration the vesting procedures under the Act. So this is what made the court determine that it could only be construed as liable to forfeiture because of the vesting procedures. So Section 3 says, subject to provisions of this Act, the land shall be forfeited. So if it's subject to, the government must take the active step of vesting the land for it to be determined that the land has been forfeited. And that was in 1995. And we are saying that in 1999, when the first amendment took place, and if we look first at Labea, in let's see. Sorry, Mala, just let me have a moment to that. Tab 118.
Wait, which tab are we looking at?
118.
118.
Yes,
This is Hughes against Lambert. Yeah?
correct. At 1136, page 1136, at paragraph 7, where they indicated that in the BVI Alien Licensing Act, it included in the act itself the finding of Young and Best, which at the very beginning, part 1, we'll see any land so held shall be liable to be forfeited to the Crown.
Forgive me, which paragraph are you reading?
Oh, the very first one, point 1. So at page
Very first
13,
Paragraph
1136.
Paragraph 7.
So it's actually, yeah,
Paragraph 7, thank you.
Paragraph 7.
7. So it's the very first one. That's 1 on page 1136. So you have it.
7, 1.
Yeah. So you
Paragraph
have it there.
7, 1.
Yes.
Right. So we have it there that the BVI Parliament inserted in their own act the words shall be liable to be forfeited to the Crown. And we are saying they must have done that in order to make it consistent with the Young and Best decision. But we are saying that in our act, the 2002 Act, they did not follow that practice by inserting shall be liable. What they did was that they deleted the basis of Young and Best, which was subject to the provisions. They expunged it from the Act. We are saying both in the 1999 Act and in the 2002 Act, which followed, because 2002 repealed 1999, they did not include the basis on which Young and Best was decided. So they removed the words subject to the provisions of the Act. So if that is the case, the very basis upon which Young and Best was decided is removed from the Act. Parliament is saying something to the court.
This is, just to catch up, we've got section 3 of the
Yes.
old Act on page 935 under
Right.
tab 101, which says subject to provisions of that.
Yes,
And you're comparing that, are you, with the new Act
correct.
on page 954, section 5,
Section 5,
which doesn't have the word subject to provisions of that.
correct.
But it does still say land shall be forfeited to the government,
Yes.
which is exactly the
Yes.
same words as in the old one.
And what you can say is that in Young and Bess at 1637 at letter E, Lord Chauncey did refer to the words subject to the provisions of the Act. Mm-hmm. But his reasoning also was that the words shall be forfeited were indicative of something that had to be done. And he emphasised that he didn't like the idea of a vacuum where someone who had a title had lost the title, but the Crown hadn't got it. Now, on your interpretation, that vacuum would exist because even under the 2002 Act, the property does not vest in the Crown until the court order is obtained.
Right. So what we are saying, Malads, that with respect to the reasoning of the Privy Council in that case, there is no vacuum to be concerned about, because if I could draw another analogy, in my study of the British Constitution, Malads, I was taught that the British sovereign is the Queen in Parliament. And a learned author, I recall, posed the question, where is the sovereign between the dissolution of Parliament and the opening of another session of Parliament? Would the court say that there is a vacuum in the sovereignty of the British government? I would say no.
Well, I'm not sure if that's a helpful analogy. Who owns the property on your thesis?
Yes.
If the owner is divested by the absence of a license and the property isn't vested in the government? Who owns it at that time?
My Lord, what my submission would be in that case is that if we were dealing with unregistered land, there would be an issue. But we are dealing with registered land.
Yes.
And an alien who is unlicensed would not be registered on the register as the owner. The owner would remain the original vendor. And anybody taken from that original vendor would take good from the vendor.
So you say that you say the original vendor, all that would happen is the trust that the original vendor had by virtue of the purchase would lapse, and the original vendor would remain the owner.
Well, this is what I would be saying, my lords. We understand that the alien purchaser would have an interest based on contract, but he needs to take the extra step to register his legal title on the register. If he hasn't done so, he's not registered on the register.
Well, that goes back to your first point.
Yes. So what we are saying,
We're looking at this Act, the new Act, the 2002 Act, on the basis that Young and Best was right as regards the 1973 Act, but has been superseded by the 2002 Act.
yes.
In view of Section 22 of the 2002 Act, which says that it doesn't affect the estate or interest of an alien held by the alien at the commencement of this Act, and it doesn't apply to a trust in favour of the alien subsisting at the commencement of the Act, how does it invalidate whatever interest Mr. Hedrick and after him Mr. Schafer held in the land, even if you're right about it superseding Young and Best?
My lords, we're saying that the 2002 Act does not create a trust.
It doesn't create a trust, but it doesn't it doesn't affect anything that's happened before it came into force. And everything that we're concerned with, apart possibly from the substitution of Mr. Schafer, happened before the Act came into force.
Yes, my lord, we accept that, but we're saying the policy of the Act was not changed, right? So while the law was amended, it was not amended to change the position of how the alien can assert rights. It changed the position as what we are saying in relation to the construction of the Act, which was construed in Young and Best. So,
Well, let me assume, for the sake of argument, that you're right about that.
yes.
What effect does that have on the pre-existing interest, whatever it was, which Mr. Hedrick and after him Mr. Schafer had when the new Act came into force?
Well,
What did it do to whatever they had?
Yes. So what we're saying, my lords, is that interest that he had was created on the contract. So he cannot assert a proprietary right against third parties if it's not registered.
Well, that you said on the basis of your interpretation of the 1973 Act, and I understand that.
Yes.
And if you're right about that, then it doesn't matter whether the 2002 Act made any difference or not. It would only matter if you were wrong about your interpretation of the 1973 Act, and that in accordance with Young and Bess, Mr. Hedrick did acquire a proprietary interest which he could have protected and did protect by the caution. Then it may matter that the law was changed by the 2002 Act. But what I'm having difficulty in understanding is how it affected whatever pre-existing interest Mr. Hedrick had.
Well, we're not saying that it affected his interest, his pre-existing interest, because what we are hitting on is that his pre-existing interest was not proprietary in nature.
It was in the
Yes.
proceeds.
Yes, but you're accepting that you cannot rely on the 2002 Act to abolish a proprietary interest which Mr. Hedrick had obtained before then. You accept that. But your argument is he never had a proprietary interest
Yes.
because your interpretation of the 1973 Act, in particular Section 13.4, you say that he never acquired such an interest at all.
Yes.
But that's back to the first point.
Yeah.
Yes. Yes.
So, but are you accepting that the 2002 Act doesn't help you, except, as you would have it, that it is consistent with what you say was all along the policy?
Absolutely, my lord. Yes, but I would also say that because we are further submitting that the basis of the
You're
amendment.
wrong on the first point, you're stuck because of section 22(1)(b).
Section 22(1)(b).
Yes.
Of these 2002
Of the
Act,
2002 Act.
the saving provision.
It's the point that it doesn't affect already vested interest.
Yes, and what we are saying that does is that you must have had the interest, and it obviously speaking to a licensed
I'm
dealer.
right, if you're wrong about that, then you can't rely upon the 2002 Act because you're stuck by section 22(1)(b) of it.
Yes, so, but what we are simply submitting, my lord, is that his interest, the previous interest of aliens registered, that's not the intention of Parliament to change it.
Right, well, I think we've got that point now. Thank you.
Brilliant. Right. And I also wish to refer your lordships to tab 42,
Of the bundle.
volume 2.1.
Yeah?
So let me see. 2.2. Just give me a moment, my lads. Hold on. Number 67. Yes, no. Yes, my lord. In fact, I wish to refer instead to tab 67, volume 2.2.
Is that 2.2? Volume 2.2.
2.2. Page 303. My lords, we are relying on this because we are submitting that was evidence before the court as to the true purport of the Act, the alien licensing legislation. What was the policy that was seeking to be enacted? And what is...
That's not a matter of evidence, it's a matter of construction.
Say again, my lords?
Matter of construction.
The policy of the Act is not a matter of evidence. It's a matter of construction of the Act.
Yes, my lords. But what I would submit, my lords, is that the evidence that came through the mouth of the first appellant was nonetheless evidence that the court could take into consideration, because that is evidence before the court, my lords.
What, about the policy of the Act?
Yes.
So, in another case about the Act, in which the same evidence wasn't available, the Act might mean something different?
Not at all, my lords. But this is true evidence that is expressive of what it is that Parliament was seeking to address. What is the mischief of the Act? What mischief was the Act seeking to suppress? And it is relevant for the court to consider in determining the rights of individuals, because that is what we determine to be the immutable public policy that is meant to be protected. In the case of Murphy and Quigg, which is relied upon.
Well, this is your speculation is forbidden point.
Yes. Yes. So we are.
I think we understand that.
Very well. So I'll not go any further on that point.
But has there been any finding by the judge at first instance that either Mr. Hedrick or Mr. Schafer was speculating? My recollection is there's a clear finding that Mr. Schafer was not, but no view was expressed one way or the other about Mr. Hedrick. Is that not right?
Yes, the learned judge did find that. Yes, that was his finding, which we are disputing, my lord, because we say that there was ample evidence that there was no other purpose for the land, and what is gleaned from the evidence that there was always an intention to sell from the very beginning.
Yes, you say the power of attorney, for example.
Yes.
That technique
Yes.
meant that he'd no intention of placing himself on the register.
Correct.
As owner. Yes.
Yes. So my lords, does the bench understand the point I'm making in relation to the legislative implication of altering the decision of Young and Best. Have I made the point clear, or would the court like me to go further?
I think we have that reasonably clearly, unless anybody else would like to ask a
Very well.
question. Thank
Okay. My lords, and on that point, I think it is useful for me to go to the point of evasion, which we addressed at paragraph 12 of our submissions. And that is at page 12. So paragraph 12, page 877. My lords, we are saying that there was evasion apparent on the documentary evidence and the evidence disclosed at the trial, which neither the low court first instance judge took into consideration or the Court of Appeal. And it is a relevant fact which would affect the rights of parties to assert any right that they purport to have.
This is a sort of clean hands principle, is it?
Yes, my lord.
That's where it's going.
Yes. So in essence, what he had was an equitable interest, and in order for him to assert that equitable interest, he had to say that he came with clean hands, he was not affected by laches, which we say that he was, and the courts below never gave consideration to these factors. And it is a basis on which...
So this is a laches point, is it?
It's a laches point, that's one aspect
And
of his...
clean hands point.
Yes, and clean hands point.
But it
So
depends on
two
making
points...
a finding of fact for the first time that that neither of the courts below have been prepared to make.
Yes, because they never considered it, my lord. That's our submission. That we made the point, they expressed no view on it. The first instance judge said he did not find that the evidence established evasion, and we are saying it was quite apparent that there was no other construction that could be given to what was happening in this matter. Because, first of all, he said the respondent was unaware of a license and therefore could not have been evading. But it was established in the evidence that he was aware, and the judge was mistaken on that point. And we are saying the evidence amply disclosed that there was an evasive intent from the very beginning of this transaction.
Yeah.
My lords, we ask that the court view paragraph 12.5.
But if you have avoidable right, why can't you just hold on to it?
Well, it is a basis upon which the court can consider, because if the matter never came up to court, of course he can do what he wants. That's my lord. But if the matter has come to the attention of the court and a party has led evidence, and we are relying on the respondent's own evidence to show...
But hang on, but if you have a voidable right,
Yes.
a right which you're entitled to hold, if you like, unless and until the person who has the right to avoid it avoids it, then whether you do anything or not is neither here nor there, isn't it?
But there's no evasion, in other words, because the only rule that is to be evaded is that the interest may be set aside by an application to the court.
No, my lords. What is evaded is the conditions of a license, my lord. That you cannot hold land because the purpose of...
Why not? Under the law as it stood then, why not? Under the decision of the Privy Council as it stood then.
Because...
simply do nothing.
No, my lords, I don't think it was indicating that you could do nothing. What it was indicating that you had to apply, and if you didn't, then it was liable to forfeiture.
Yes.
However, the courts have never, in the previous...
Only liable
Yes.
to forfeiture by the state.
Yes, but why we are saying this is a novel case, my lords, is that the previous decisions never dealt with an issue of evasion. What they dealt with was whether an alien who took steps to do something with the land but didn't have a license, and so he had a great interest and he was showing that he was doing something active. So it would be inequitable to forfeit his land automatically. But there has not been a decision.
Because he was developing it.
Yes, because aliens are only allowed to purchase land in St. Lucia for development. And I would make the point here, my lords, St. Lucia is a small island, 238 square miles, 2 resources.
You're now saying he should have been speculating.
Absolutely not. Absolutely not, my lords.
No, by speculating, you mean holding land and then selling it on at a higher price?
Without development.
Without development.
Without development. That is what speculation is, my lord. It is an evil, my lord. I would submit...
So if you build a house on it in order to make more money out of the whole shooting match, that's not speculation.
Absolutely not, because you have developed.
But I mean, it's an evil which the government has every right to deal with by stepping in and forfeiting. That hasn't happened.
Absolutely, my lord.
That's the remedy for the evil.
Yes, but what I'm saying is, if that which justice sees, that what justice seizes, if the alien has not subjected himself to regulation by going forward, how can the government take a step to forfeit? Because they are unaware that this individual is operating on the island. They can't take any step. And to determine otherwise is to read down the act and to make it entirely relevant.
But I mean, the Smiths had a license, if I remember right,
Yes.
to develop, but they had to develop within 3 years. They were in breach of that by the late 1980s.
Yes.
The government could at any time, if it had wished, initiated a forfeiture against the Smiths,
Which they did.
which they didn't, but they could have.
They did. In 2002.
They didn't initiate a forfeiture. There was
Well,
an
they
exchange
wrote
of
a
letters in 2002, and inquiries were made. And if I remember right, your client was asked to get in touch with the
Yes.
Smiths,
And nothing happened.
and nothing happened. And nothing happened for 3 years.
Right. So, my lords, we are saying the government commenced steps for forfeiture.
We commenced inquiries as to whether, presumably to make inquiries of the owners to say, well, what are you going to do about it? Because if you're going to do nothing, you're liable to forfeiture.
And that-
But no forfeiture was initiated.
Yes.
No court process was entered into.
And that's our very point, my lords, because the alien is licensed and registered. But what would have been, how could the government have intervened if there's no license, the alien is not even known to be operating in St. Lucia? How could the government take any step? The court must consider that, because an unlicensed alien cannot be in a better position than a licensed alien who is on the
Well, I
register.
think we have your points, and you set it out in considerable detail in the paragraphs of your case that you've just mentioned.
Thank you, my lord. My lord, I really would be remiss of me not to refer the court to the power of attorney itself, which the power of attorney itself
Yes.
of the
Yes.
respondent. Where the document I prepared.
It's volume 2.1, page 164.
Tab 29.
And my lords, we are saying if the sorry, my lord, let me let you get that.
Okay, can you just ask him how? That's a little slow.
Because we break at 12.
Yes.
Because what we are saying, my lords, is that if you are coming to the court to assert your right for one specific performance and for legal title, at the point in time, 14 years ago, when you had the opportunity to do so, what you did instead, because you are claiming, first of all, that you have paid the full purchase price, and now you're coming forward to say that you want title to this property. And Mr. Smith was holding the property on trust. We are saying this power of attorney belies a trust, because it says it grants Mr. Hedrick the power to sell the land to any party, including to himself. And we are submitting that that is inconsistent with the respondent's case. Because if you've already bought the property, why would the power of attorney say to sell to yourself? It's equivocal. And second of all, why didn't he exercise the power under the power of attorney to alter the state of the register? And we are saying he didn't do it because he intended, my lords, to transfer the property without having to apply for a license, because as the respondent admitted in evidence that that power of attorney allowed him to stand in the shoes of Mr. Smith. So we are submitting that he usurped the license of the Smith. That power of attorney prevented him, or precluded, I should say, from having to apply for a license, because he's now merely operating as an agent for the Smiths to sell.
Some might say, so what?
Well, my lords, we are saying that would defeat
The what?
the land registration system. That is not how it is intended to operate. When you purchase land, you have to immediately go forward to register your title. Because how else would other parties be able to govern their relationship? And if you've not even registered your power of attorney, you would induce other parties to act to their detriment, my lords. This is not a transaction that is commended to conveyancing lawyers, my lords, that you obtain a power of attorney and you wait 14 years before you alter your title, and when it is affected by a purchase, you come forward to the court and say, forget that I've missed out on the last 14 years. Forget that I've said I've paid the full purchase price and I've not disclosed that on the register. And we must remember that when the executor went to alter the status of the caution, he never disclosed the full purchase price. He held that back. He should have entered that on the caution. He should have changed its status. And they were definitely notified.
Sorry, what, to change the status of the caution?
So in other words, the
to
caution,
register the power of attorney? Is that
no,
what
we're saying that when he went to substitute himself on the caution,
Mr. Schafer?
Mr. Schafer,
Yeah.
he should have disclosed at that time, in 1999, when he did so, that the full purchase price had been paid. He did not do that.
Oh, I see.
He didn't. And then he went forward to the registry of probate and never declared the property. So we're saying all the surrounding circumstances would cause a reasonable party to conclude that there was no proprietary interest that he was seeking, which is consistent with what the March 1st letter interpreted it as. And we are saying if you are asserting legal title, you're asking the court to allow you to exercise your right based on your contract, the court must consider how long it took you to ask for this right, and secondly, what was the true intent of that contract. We are saying the true intent of that contract was not to transfer title to Mr. Hedrick. The point of this contract was to allow Mr. Hedrick to sell this property, my lords. And this is what has been achieved. So the ultimate aim of the parties, and is evidenced by this power of attorney, was that the object of this contract was not for the transfer of title to Mr. Hedrick, but was to allow Mr. Hedrick to dispose of the property via sale. So what they were interested in was the proceeds, the realizable value of the contract. And my lords, the learned authors in Cheshire and Fivefoot stated, quoting a learned justice, that the purpose of enforcing a contract is to ensure that the reasonable expectations of honest men are not disappointed. And we are saying if the court looks at the true intent of this contract, it was not to give Mr. Hedrick title, legal title, and to vest the property in himself. This power of attorney negates that. It says for him to sell, and all the evidence throughout is that he was attempting to sell the property. He entered an advertisement in 1991 at the very point in time that he placed his deposit for sale. And he made attempts to sell the property. In evidence, Mr. Schafer admitted no one in the family was interested in the property. He never declared it in the probate registry, and when he went to Parliament to apply for a license, he indicated that the purpose for that license was to liquidate the assets of the deceased. So what we are saying, the true intent of this contract that he entered into with Mr. Smith was to realize the value of the land, the proceeds from sale. The land was sold, my lord. And if the reasonable expectations of men are not disappointed, what is his complaint? There is no complaint on the face of this document, my lord. What his real complaint is that he is unhappy with the price at which it was sold. He wanted to sell what was building land, but which was described, or the license required for agriculture, but he wanted to sell it as building land to get an inflated value for it. And we are saying that the price that the appellant paid, there's an internal consistency with the price. 300, 400, 560. The respondent is asking for this external, outside, inflated version of 3 million EC, if I can put it that way, 3 million EC. And we recall he's only put $20 to place a caution on the property in St. Lucia, and he's wanting to sell it, not in St. Lucia, but abroad for $1.1 US, and he has contributed $20 to our economy. That is £5, my lord. £5. And there is law saying, do not speculate, and that is what is being found, an unlawful act, and he's claiming an equitable interest, and the court will turn its face from that and say, so what, my lords, we strongly submit that this is not a case of so what. No. Land is important to St. Lucia. This is two resources. We have land and people. Parliament specifically legislated to say if you want to participate in St. Lucia and purchase land, you must do so for development.
Right, well, I think we have that point.
Yes, very well.
Specific performance.
And my lords, I think that goes as well. Because he's claiming an equitable interest, he ought not, his right of specific performance ought not to be enforced. Because again, it goes back to the point that his purpose was not to vest title in himself. It was not to pursue legal title. It was not to develop land. He got what he wanted. He got the sale, but just...
That's the same point.
Yes, so he ought not, based on evasion and speculation, specific performance ought not to be granted. And if he's relying on Lehrer and Gordon, in that decision, the basis on which specific performance was granted was because the alien in that case was prevented by the vendor from implementing his purpose. But in this case, there is no purpose before the court as to what specific performance should be granted to the respondent to do. And my lords, I think I need to refer to the point on go on to inquire, that the appellants, the first and second appellant, should have gone on to inquire of Mr. Schafer the status of his transaction. We're relying on paragraph 7.12, 7.18, and 7.21 of our submissions.
What does this go to? I mean,
Lords, I think
if Mr. Schafer didn't have an interest that bound your client, it doesn't matter whether you asked him or not.
Yes.
And if he did, then you had notice of it because of the caution.
Yes. But it was a finding by the court below, my lords, that even if the first and second appellants had not been informed of the payment of the full purchase price, he was not in good faith because he ought to have gone on to inquire of Mr. Schafer the status of his transaction. And we are submitting that that was a wrong proposition in law, where the judge went wrong.
Where does it get you? Either you don't need to be a bona fide purchaser without notice, in which case it doesn't matter, or you need both to be bona fide and without notice, and you had notice.
Yes, I think where the learned justice was thinking is that had you inquired, you would have had the notice.
You'd have had more notice.
Yes, you would have had more notice. There you go.
I'm
Yes,
not sure that makes much difference.
yes.
Any notice is good enough.
Very well.
But your view on specific performance also has to take into account what the Privy Council said in Edwin Hughes and Labaya.
Correct. Yes, my lord.
You're coming to that.
maybe I should.
Yes, what, tab 118 at page 1146. It's Lord Walker at paragraph 40.
Which paragraph?
40.
40.
Where the board look at a decision in equipment rental.
In terms of the specific performance, Mother?
Yes. They talk about Young and Bass.
Right.
And then say that that decision reduces the draconian nature of the legislation, but it doesn't touch on the issue of specific performance, where the court is ordering a contract to be completed and says that in equipment rental services and Texco, the court faced up that issue, and there's a statement of principle in the indented paragraph.
Right. So, my lords, yes, we are not saying that specific performance could not be granted in the proper case, right? So we are not submitting that at all. But we are saying this is not a proper case. Because in all of the other decisions, I would challenge my learned friends to come up with any case that's been cited under the Alien Licensing Act, where an alien has done this, what we are purporting that has been done. All the other cases was that an aliens were doing something, and they were in breach. Not that he never applied for a license and sat back for 14 years and did nothing. So we are saying this is not a proper case for specific performance. And I think that point is assisted by paragraph 36 of that same decision, which is on page 1145. 1146, paragraph 36. Otherwise, if we look towards the top of that decision, with respect to leches, and it explains what leches is.
What paragraph?
Well, that's right to the top, my lord. I would say the first one, and the judge is citing.
But what's the paragraph number?
36, I think.
36.
Well, we have Lord Justice Morbitt's principle at just the end of the paragraph.
So it's a matter of degree.
Yes. So our submission, my lords, is that.
You say this is too long, yes.
My lord, how could any commercial transaction be allowed to operate in a time span of 14 years? And you have done nothing. And I would also rely on the authority of my learned friends in Shaw and Foster, because the very decision that they're relying on and the principle that they're relying on was not applied in that case. And my lord, if I can take you, Shaw and Foster, Elizabeth. Look at this. It's 142, my lords. Tab 142 of volume 5. My lords, we are submitting that the basis on they're relying, my learned friends are relying on the principle of the contract and the creation of the trust, because the party in that case was relying on it. But the courts dismissed that appeal on the basis that that principle did not apply to that case for a number of reasons. And the paragraph I wish to rely on critically is on page 1526. Towards the top, my lords, perhaps the first paragraph where it says, ought the bank to have been contented with giving such a notice and to have considered that enough had been done in the way of warning to Sir William Foster, and I will not read it for an interest of time, from ought to care to possess, and also the final paragraph, under these circumstances, the banks have deliberately adopted the form of notice upon which they were content to rest. Did anything occur between the time of it being sent to Sir William Foster and its completion, which ought to have operated as a warning? Further down, I would say in that same paragraph, it says they knew that the time for completion of the contract was the 30th of September. It was actually completed on the 21st of November, yet the bankers made no inquiries.
This is all about what's sufficient notice.
Yes,
Yeah.
correct, my lords. And if we can go to 1528,
So what's the proposition of law for which you're citing this?
this was the proposition of law, my lords, that the banks were claiming an interest based on an assignment of a contract to them. And he had sent a letter to Mr. Foster saying that Mr. Pooley had... Sorry?
So?
Well, yes, my lord, what I'm saying is that they are claiming the same interest that the respondent in this case is claiming, that he had an equitable interest in the property. And this decision did not apply that principle because they found that the bank had not done all that it was required to do in which to protect its interest.
To give adequate notice to Sir William Foster.
Yes.
Yes.
And we're saying at 1528, it says, it is impossible to acquit the bankers of great neglect, both in the form of the notice which they gave and in afterwards reposing upon it. And that is in relation also to the point of laches. We say the respondent in this matter reposed on his rights and did nothing further to improve its status.
Right, well, I think you've got 5 more minutes.
Yes, my lord, I am drawing to a close. My lords, I think I would rely finally on 2 portions, which is on page 1544.
This is
Of Shaw, yeah, 1544.
Sorry. Thank you.
I'm not with you, Mr. Snack. What are we looking at?
1544 in short.
1544, and in the second paragraph, my lord. But it's saying that the bank is saying Mr. Foster should have made further inquiries. And what the learned justices indicated that what duty did it cast upon him, meaning the notice, the letter of notice. Was it his business to hunt out information as to the making of the request or the execution of the assignment? That information the bankers necessarily possessed, and it was, in my judgment, their duty to give it and not the vendors to seek it. So, in other words, we are saying he should have disclosed his full interest in the probate registry. When he substituted himself on the caution, he should have updated it to indicate that the full purchase price had been paid, and it also indicated at paragraph 1546.
So, but just tell me what principle of law you're citing this for.
The principle of law is that,
laches.
the principle of law was that there was no duty upon the first appellant to go further and inquire of the respondents the status of his transaction.
Back to the inquiry point.
Yes, okay. So that was not his duty. The duty was on the respondent to disclose his full interest. And finally, my lord, just the final paragraph here is on page 1549. Where it simply says the parties, they were unwilling themselves to take any step to complete it and sought, in fact, to obtain the benefit of the charge without performing the burden still remaining to be discharged. So we're saying the respondent simply relied on the caution without executing anything further, which was to establish his right, and based on that principle, the court did not enforce the notice which the bank was seeking to rely on. Lords, thank you. That is the end of my presentation.
But could I just mention one point which you haven't mentioned at all?
Yes.
But has struck us, that what is the position in relation to the order for damages? Is there any issue before the board about, in relation to the order that the judge made for damages?
Damages have not been assessed.
I believe that was to be assessed, my lord.
And you're not complaining about that?
But there's 2 points, really. One is, to induce a breach of contract, you have to know that there was a binding contract, and your position is your client didn't.
Correct.
And you also claim, there was also a claim made against you, I think called a procuring breach of trust, which
Yes.
presumably was some form of knowing assistance in a breach. And there has to be a finding of dishonesty, and there's no finding of dishonesty against your client. So on what basis is your client being held liable in damages? I think that's the question.
Yes.
Yes. I think your lordship has captured it.
And that's covered in your ground 8, I think.
Yes.
Yes, but I think we addressed all the points that
Yes.
needs to be raised before your
Just
lordship.
adopt what's the...
Yes.
Thank you very much. Well, I think we'll just adjourn for a moment to consider where we've got to in the appeal.
Just adjourning for 5 minutes.
Thank you, madam.
Would you like to add anything yourself to the argument?
Well, my lords, I was hoping to address you on the matter of cost.
On costs?
Yes, my lord.
Well, we'll come to costs at the end.
Very well, my lord. Thank you.
All right. Well, now, Mr. Foster, we've, I don't think we need to trouble you on the principal points we've been discussing this morning, but we are somewhat concerned about the position in relation to the damages, because and this is a point I think taken on the other side, although it's only referred to in the written submissions, but we're just a little concerned about the nature of your case on damages, how precisely it's put, and what sort of damages are being sought.
More what sort of breach
In respect of what breach of duty?
Curing the breach of trust.
The breach of what transpired in this case, as your lordships, I'm sure, have fully understood, is that this was a transaction between Gail Hedrick and the Smiths that took place in 1991 and 1994. The Snacks were nowhere in the picture. It is in 2006, after Mr. Snack had learned that Mr. Hedrick had died, that Mrs. Benton had was offered the property after his death for $1.1 million, and Mr. Snack then went about having notice, full notice of the transaction between Mr. Smith and Mr. Hedrick, went about to try and register a deed of sale.
But he failed.
Which he failed to do.
So what's the loss?
We're not taking up that point, my lord. The judge did not find dishonesty on the part of
the trusts.
with relation to the trust.
Since the judge did not find dishonesty, as you acknowledge, there can't have been dishonest assistance in a breach of trust, so that's not within Brunei and Tan. And there was no receipt of trust property either, was there, knowing or otherwise?
No.
So a claim based on what is called procuring a breach of trust, which is, under English law, must be either dishonest assistance or knowing receipt, must fail, mustn't it?
Yes, my lord.
So does that mean that the judgment against the Snacks, the money judgment, cannot stand?
For breach of trust. Yes, my lord.
Or is there any other way that you put the case?
It was for assessment of damages, and that has not taken place. We have not pursued that.
Could we just look at the order that the judge made?
Page 306 in volume 3.
Yeah. Paragraph, the points we've been discussing this morning relate to paragraphs 1, 2 and 3 perhaps. We'll just leave costs out for the moment. Then we come to paragraph 5
6, really.
and 6. Well, first of all, in 5, this is against the ancillary defendants. That's Mr. and Mrs. Smith, is that right?
Yes, the ancillary defendants are Mr. and Mrs. Smith.
Now, are you seeking, in real life, are you seeking damages for breach of trust against them now?
In light of what your lordships have said, because there was no such finding, I take it that we can't pursue that head, although the evidence was ample to indicate that there was.
Well, is that right? As against the Smiths, who are the ancillary defendants, you don't have to prove dishonesty. You just have to prove a breach of trust. But then the question, as my lord put to you, is what loss is suffered? I can't think that a court of equity would award nominal equitable compensation. A common law court might, but an equitable court of equity wouldn't. And if you succeed on the property aspects of the case, so that Mr. Schafer can now proceed to register his title, is there any loss at all?
He has registered his title, it's just that he has not dealt with it, with this property, from 2006, from the time this issue has arisen. It's 9 years, 10 years of having this matter in abeyance.
Because of this litigation.
Because of this litigation.
When did he obtain, finally, his alien's title?
2011.
Yes, so he couldn't do anything with the property before then?
He could have sold the property. He has not because of this litigation.
Well, but he needed his license, presumably, because otherwise he would be selling a property which was subject to avoidable title.
Yes.
So he had to get the license before he could deal properly with the property.
Yes.
Which wasn't approved.
It was that during this litigation, that process was on hold pending the litigation.
The license was approved.
The license was since approved. The property has since been registered in the estate of Gail Edric.
So the question still remains, what if any claim, what if any monetary claim are you making against the Smiths?
Well, given the Smiths' economic circumstances, the economic answer is probably very little, right. I suspect. But you haven't considered that yet, have you?
No, we have not considered that.
They're not before us, the Smiths, are they? Or-
They are.
They are.
They are.
Oh, they are, yes, of course they are. Yes, I'm sorry, yes. So what, yeah.
Well, then let's just go, we'll come back to that in a moment, maybe. Let's go on to the claimants. That's Mr. and Mrs. Cenac. It's paragraph 6, little 2, I think. But there, are you now seeking are you claiming damages from them or not? Or not? If you're not, it would be better if it was removed from the order so everybody knows what the position is.
Are we removing this? What were the damages? It's We haven't addressed our minds to this, to all my lords. This was not part of the appellant's case.
Well, I think it is.
I think they do.
Yes, I think it was ground 8 deals with the point.
Issue 2, I think. Issue 2 on the list of issues.
Yeah.
We can't say that there has been any monetary loss except the huge cost.
Well, costs are something different. I mean,
Yes.
And costs are dealt with in paragraph 4, aren't they?
Well, so far as you put the case as being procuring a breach of contract, the absence of any loss would be fatal. And so far as you put it on procuring a breach of trust, the absence of a finding of dishonesty would be fatal. So in either case, as against the Cenacs,
Not looking too promising.
I can't see how you can be entitled to any monetary relief at all.
I take the points, my lord. My lords.
Very well, thank you very much. Well, we'll probably deal with it on that basis and remove that from the order. But going back to the Smiths, you want to leave that open in case you think of something in the future, is that right? Or
Yes.
somehow the idea that there's going to be any, as my lord pointed out, the idea there's going to be any worthwhile monetary claim against the Smiths seems rather far-fetched.
We don't know, but I suppose, but the Hedricks came
Well,
in
anyway,
to
that's-
bail the
that's-
Smiths out, as I recall.
That's a commercial judgment for your
Yeah.
clients, not really
Yes,
for us.
The court.
All right, thank you very much. Well, I think we have the point about that. Now we'll just go over to the other side and ask him what point he's got on costs. Could you tell me what your name is? I'm awfully sorry. I haven't got
I'm sorry, my lord. My name is Leslie Prosper.
Right, thank you.
Thank you.
So what do you want to say about costs?
Okay, my lord, the last document the court considered is the learned judge's orders. I'm speaking particularly to paragraph 130,
Yes.
Yes, that's what we were looking
subparagraph 4,
at. Yes.
where the learned judge indicated that he was awarding costs on a claim valued at 560,000 EC.
Yes, well,
Yes,
speaking for myself, I didn't fully understand that, but
Yes, my lord. My lord, I recognize that this is a challenge to the exercise of the learned judge's discretion, and I'm very much aware of the appellate approach to the exercise of judicial discretions.
Do we have part 65 of the...
Yes, my lord.
Anywhere in our-
I made copies of it, my lord. Both parts 64 and 65. Can you pass one to Rennie?
and is this point discussed in your case?
Pardon? All of them are the same. It's for the court. Yeah. That's enough?
Probably. Yeah. Let's just see what it says there. I agree.
Thank you.
Is this point in your printed case?
Pardon, my lord?
Is the point on costs in your written argument?
Yes, my lord. It is at the end.
Ground 20, page 895.
My lords, take a look at
What? 20.
Round 20, yes. Paragraph 18.
paragraph 18, page 895. And my lord, the real challenge is the exercise of the judge's discretion with regard to the matter of quantifying cost. And CPR Part 55 provides three means by which costs can be quantified. These are set out in Part 65, the document I just provided, Part 65.3.
Yes.
Yes, it says that costs can be quantified on a prescribed cost basis, budgeted cost, or if neither of these apply, by assessment in accordance with 65.11 and 65.12. My lords, if I direct your minds to prescribed cost, which would be under 65.5, subrule 2, it speaks to how the court is supposed to ascribe a value to a claim.
Yes.
My lord, if you take a look at subparagraph B particularly, it says if a claim is not for a monetary sum, it is to be treated as a claim for $50,000 unless the court makes an order under 65.6, subrule 1A. My lord, if you look at part 65.6, it specifically speaks to the matter of an application having to precede a claim being valued. So in the absence of an application under Part 65.6, the judge had no alternative but to revert to 65.5, subrule 2B. So the claim really ought to have been valued at $50,000, my lord. And if you take a look at the reliefs that the Cenacs were claiming, my lord.
B.
Yes, my lord, that's right. That's correct, my lord. The reliefs that were being claimed were declaratory relief, orders, and unspecified damages for the maintenance of the caution.
So your complaint is that the judge exercised the 65.6 power without an application?
Yes, my lord, which was arbitrary, it was inconsistent with the rules, and of course, my lord, it was a wrong application of the rules. Because 65.6 contemplates the natural justice principles. Both parties make submissions and the court fixes a value at that point in time. But what he did was he arbitrarily affixed a value of $560,000.
But without any submissions about it?
Pardon, my lord?
Without any argument about it?
Without any argument. That's exactly the point we're making, my lord.
Was this point made to the Court of Appeal?
No.
No, my lord.
I mean, it's classically a matter which...
It's a bit late by now, come to ask for it.
Well, my lord, I have an authority that tends to suggest otherwise. My lord, if you take a look at...
But if the claim was a claim, or included a claim for damages, which I think you said it did, why is it not within 65.52A, in which case the judge has the power to stipulate the value of the claim?
Because, my lord, I still go back to Part 65.6. It has to be premised on an application. Otherwise, my lord, the court can arbitrarily affix values to claims, and costs can become quite outrageous. And in this instance, my lord, if the cost orders are to stand, I've done the computations. The High Court, you're talking about $62,950. The Court of Appeal is 2/3 of that, which is another $20,962.
I mean, your point would have a lot of force if 65.2A referred to 65.61A, as paragraph B does, but the fact is that it doesn't.
But it's a little odd.
Well,
because it seems to be related in some way to the claim for damages. And if there isn't a claim for damages, or the claim for damages is nil, it's a bit difficult to see how you get to the kind of number that the judge came to.
And the basic problem is this is a matter of procedure in St. Lucia.
Yes, my lord.
On which the board would normally attach considerable importance to knowing the views of the Court of Appeal. And we don't have that benefit.
The difficulty is, my lord, you would recognize that we had quite a few grounds of appeal, and it really was an omission by us. And
grounds of appeal, according to...
Yes, my lord. And my lord, I just wish to refer this court to an authority that's found in tab 5. That is, volume 5, tab 116. 116.
Connecticut Fire Insurance.
That's correct, my lord. Yes, my lord, that authority dealt with the fraudulent transfer of a fire insurance policy after the fact of the fire. And the first instance court found that there was no fraud. It went on appeal. The appellate court also found there was no fraud, but when it came before this board, for the first time the party raised the issue of negligence. And Lord Watson, in his judgment, my lord, if we take a look at page 1112, the penultimate paragraph, where it says, my lords, I don't know if you're following me.
Yes. Okay.
Yes. When a question of law is raised for the first time in a court of last resort upon the construction of a document or upon facts either admitted or proved beyond controversy, it is not only competent but expedient in the interest of justice to entertain the plea. The expediency of adopting that course may be doubted when a plea cannot be disposed of without deciding nice questions of fact, in considering which the court of ultimate review is placed in a much less advantageous position than the courts below. My lord, this is an issue, this is a legal issue, this is a procedural issue. There are no issues of fact to be decided here. So it is and my lord, I need to mention that it is part of the submissions, so my learned friend cannot argue that he's been taken by surprise. So it is my submission that this court is competent, and it's a court of last resort, meaning that it is the court where all matters between the parties should be finally disposed of. So, my lord, it is my submission that this court is competent to hear us on that matter. And it is clear, my lord, from the evidence that the learned judge misdirected himself on that particular issue. And, my lord, I need to mention one more thing. One of the justices of appeal in this matter, that is Justice Blenman, she seemed to have been at pains with regard to the quantum of the cost order in the court below. And she even made a recommendation to the parties that they try to agree the issue of cost, because she well recognized that the cost order was heavy. But the parties, unfortunately, could not agree. And, my lord, I just wish to finally mention that this...
That was one of the judges in the Court of Appeal?
Yes, my lord.
Where's that?
Let me get the precise provision, my lord. Where's Blenman? My lord, volume 3.1, tab 87, page 70. What's that? Oh, sorry, page 719. My apologies. 719. Learned Justice of Appeal, Blenman, where she says at the beginning, but couldn't the parties, that should be the parties, it has prices, that's an error, obviously. The parties agree on the issue of cost instead of going the 2/3, because 2/3 of that cost is going to be very heavy. And if we take a look at
I couldn't quite follow the next bit. I think the order of the judge is 2/3 of the contract price.
that's the order in the Court of Appeal, because the Part 65 provides that the Court of Appeal is 2/3 of whatever was ordered at the first instance court. In cost.
So she means 2/3 of the amount ordered at first instance?
Yes, my lord. But certainly she was having great pains at the cost order that was made in the court below. And my lord, I finally submit that...
So the trial judge's order was a fixed scale, was it, applied to what he determined to be...
Yes, my lord. It's a sliding scale.
Yeah.
Yes, my lord.
In the Court of Appeal?
No, first instance. It's a sliding scale. Court of Appeal is 2/3 of whatever is assessed in the court below.
But in the court below...
Yes.
What was the figure based on?
He used the value of the deed of sale, the value stated in the deed of sale, which is $560,000.
In the what?
Pardon?
Whose deed of
The
sale?
Cenac deed of sale.
The 2006 deed of sale.
That's correct, my lord.
Yes.
And what's the logic behind that? I mean, that's got nothing to...
I don't know, my lord. I'm searching for it. I don't know. Quite an arbitrary exercise of his discretion. And he provided no reasons for it.
It wasn't the usual 50, because he had a price to work with, he said.
Yes, but my lord, it has to be based on the rules.
Well, then it would be based on the rules 65.5 2A.
Except that the value in the deed of sale was not the amount of the damages, but the value of the matter, the land at issue.
Yes, my lord.
So it doesn't look as if it falls naturally within 65 2A. Yeah. And your point would be it had to go into 65.
0.6.
Which
is an application.
There was a procedural mishap.
Yes, my
The
lord.
point was not raised at a stage when you were in a position to deal with this.
That's correct, my lord.
I mean, I subject to what you said, I see the force of that, but I feel very uncomfortable about resolving a matter of this sort, of a procedural nature, without the view of the Court of Appeal.
Will we not have to remit back to the courts in St Lucia to look at, if you're right that there has been a breach of natural justice in the fixing of costs, wouldn't we have to remit back for the local courts to determine the matter?
My lord, I think this court is very competent to undertake that exercise.
Well, I think I've just suggested that I am.
It's very difficult for us if we don't know anything about the actual costs.
Also, we don't know anything about the practice which is applied in St Lucia in using these costs, which are not at all familiar from an English point of view or Scottish point of view.
You see, my lord, this has been ongoing for such a long time, and I was hoping that we could have brought finality.
What are you suggesting is the order we should make?
My lord, that it be fixed against the value of $50,000, which is pursuant to Part 65.5, Sub-Rule 2B.
That's at the other extreme, so
that's what it has to be, my lord,
I see.
in the absence of an application.
If the judge didn't get it right, well, they're stuck with their 50,000.
It might be said against you, well, the time to take all these points was in the Court of Appeal, not coming along here and later, because... Anyway, we have your arguments and we'll consider them.
Much obliged, my lord. Thank you.
Do you want to add anything further on that?
Just, my lords, that...
I mean, it is rather disturbing, because it's very, very difficult to see how, on the true construction of this rule, you could arrive at the number that the judge arrived at.
What happened, my lords, is this. At case management, there was an order that prescribed costs would apply in this case. At the end of the case, we made submissions on cost.
Before the judge?
Before the judge, before closing submissions, before the judge. The judge then fixed the value, having assessed the case. He fixed costs at $560,000.
Did you ask him to do that?
Pardon?
Did you ask him to do that?
Yes, my lord.
Right.
The
Do we have
to fix the value of the claim at $560,000.
The value of the claim?
Of the claim.
And how did you value the claim at $560,000?
What we stood to lose, that was the value that the other side had put on the value of the property.
Right.
Being $560,000.
What's that got to do with the costs?
Costs would be assessed on that amount.
Basically, this
on a sliding scale.
What you wanted was that the value of the matter, which affected the scale costs, should be determined under 65.6.
Right.
Well, we were claiming
on the basis that you would, if you'd lost, you would have been, your title would have been extinguished, effectively.
Yes. And that's what we did.
Are you saying, in effect,
you
did
damages in disguise?
Well, you did apply under 65.6.
No, that's basically.
We did not name what we applied under.
No.
But we applied for the claim to be valued. And my lord,
sorry, you applied, there was a case management order that should be dealt with the prescribed costs.
Yes.
But you say you also, at some stage, you applied for it to be valued.
In our closing submissions.
In your closing submissions.
Yes. And the judge awarded it at $560,000. And interestingly, my lords.
I mean, and did they have an opportunity to respond to your claim?
Yes, they also gave closing submissions.
So you're saying that, in effect, in closing submissions, you operated under 65.6?
Exactly, my lord.
So, or technically, it wasn't before the trial. Parties proceeded to deal with the matter in closing submissions. Is that the position?
Before the conclusion.
We don't have any of these documents ourselves, do we?
No, my lord.
There were no oral submissions, Madam. There were written submissions, and that issue never came up.
But were there written submissions on costs?
No, there were no. We submitted written submissions. There were no oral submissions before the court.
So there are some written submissions on costs somewhere
Not that I'm
about.
aware of.
Yes, we did. He didn't. He chose not to. Just as they chose not to appeal on that point in the Court of Appeal. There was no appeal on cost. And in this, before the Privy Council, they valued the claim at $560,000 as well. What's that document?
Who did the other side?
The other side.
Yes. For the purpose
Well, in
of
case
the,
they won.
Well, for the purpose of the Privy Council fees.
Yes,
Yes, it's the certificate of value.
certificate of value. So,
I don't have
Everywhere-
a certificate of value.
Yeah. How's that?
and I think it's a little late.
It's a good forensic
4,
point.
tab 96, and it values the claim at 560,000.
Volume 4, tab 96.
But no challenge was made to your written submission as dealing with costs on the basis that it should have come before the trial.
No, it wasn't. In fact, in the Court of Appeal, no, it doesn't matter.
No, at first instance, when the written submission was sent to the judge at first instance, the other side didn't say, hang on a minute, you can't argue that now. You should have done it
No.
before the outset of the trial.
They didn't.
Indeed, it is fair to say that in the document signed by Mr.
Cenac.
Cenac, he seems to accept the 560,000.
That's right.
And then advances a slightly different figure, slightly lower, which would be the value in the Privy Council if... very well, I think we'll consider in the light of this argument what to do, and if we want any further submissions from the Council, we'll let you know. But thank you very, very much for all your assistance.
Thanks, my lords.
The Lordships will take time to consider what advice humbly to tender to Her Majesty. Thank you very much.
Much obliged, my lord.